We can. All right. Thank you so much for joining. If you allow me just to say a couple of words, then we can get started. So thank you so much, Dr. Ramluckan, for joining us today. Before we get started, I would like to just acknowledge some of the technical issues that we faced yesterday during the opening ceremony. There were so many of you, and unfortunately, because of the success of the event, we were unable to have our network handle the issues. So we've made the necessary changes to ensure that the next lectures run smoothly. Unfortunately, today we had the force of nature against us and a flat tire. So hopefully moving forward and with the help of your patience, we can get better at this. Today we have Dr. Trishana Ramluckan with us. She's an honorary research fellow at the School of Law, University of KwaZulu-Natal. She's a member of the IFIP working group on ICT uses in peace and war, and she was listed in the top 50 women in cybersecurity in Africa 2020. So today, she will provide us with a lecture on an overview of South African cyber law and policy. Just a quick reminder for all of the students, we will take questions at the end of the class. This will be done in the Q&A function. Please reserve this box only for questions related to the content of the class. And if there are any technical issues, please send us an email. All right, thank you so much. I will now give the floor to you, Dr. Ramluckan.
Thank you. And thank you all for getting it through. Okay. So today I'm just going to do a short lecture because of time issues. It's an overview of South African cyber law and policy. Let us start. Okay, so just an introduction to South African law. So we first have the Constitution, which is the highest law in South Africa. Then we have our IT and information laws, which we're going to look at. This includes the ECTA, or Electronic Communications and Transactions Act, RICA, which is your Regulation of Interception of Communications Act, POPIA, which is your Protection of Personal Information Act, the Promotion to Access to Information Act, which is PAIA, your Cybercrimes Act, the National and the National Cybersecurity Policy Framework. Other areas that we might look at is the Public Finance Management Act, which is your PFMA, your Film and Publications Board Amendment Act, and your Consumer Protection Act. Okay, so if we look at the ECT Act, Act 25 of 2002, what's its purpose is it sets out basic e-strategy and regulates electronic communications in South Africa. The Chapter 1 is just your interpretation. Your policy framework is Chapter 2. Chapter 3 is facilitating electronic transactions. Chapter 4, e-government. Chapter 5 is cryptography. And it carries on for quite a while until we reach Chapter 14, which is your general provisions. The important aspects of this is your Chapter 12, which is cyber inspectors, Chapter 13, which is cybercrime. Okay, next we have RICA. And before I go to RICA, it must be mentioned that certain aspects of RICA has been deemed unconstitutional because of POPIA coming in and privacy issues. So first of all, it's still being addressed, so we haven't heard anything thus far, but it was Act number 70 of 2002. What we know, if we're having to register our SIM cards, so previously in South Africa, we had to register all SIM cards. Now it's not as strict as it was before. You can do it online if you want. Regulates the interception of monitoring of communication, including radio frequencies. It regulates requirements for interception, so law enforcement and telecommunication providers. So I'm not going to go through each single chapter because I will ensure that you get the slides, okay? Chapter 1, General Provisions. Chapter 2, Prohibition of Interception. Chapter 3, Applications and Issuing of Directions and Entry Warrants. Chapter 4, Executions of Directions and Entry Warrants. Chapter 5 is Interception Capabilities. 6, interception centers. 7, duties of telecommunication service providers and customers. Chapter 8, general prohibitions and exemptions. Chapter 9, criminal proceedings, offenses and penalties. Chapter 10, your general provisions. This is an important one. So this is POPIA, which is your Protection of Personal Information Act. The draft bill came in 2009. Excuse me. Act 4 of 2013, but it only commenced in June or July of 2020, and compliance was regulated or required by July 2021. Some key points. So what is POPIA about? It defines personal information and special information. It regulates the capturing and processing of such information. Condition 7 has your security safeguards like confidentiality and integrity, and addresses trans-border flow of information. It also regulates the penalties awarded in such cases. So I will give you an example of this. At the end of POPIA, you have your key rights. So what are the key rights under POPIA? Individuals have the right to know if an organization has information on them. Individuals have the right to request information that has been changed or updated. Individuals have the right to be forgotten. So if you don't want your personal information kept within an organization, by your permission, they have to actually get rid of it. Opt-in direct marketing. Now that's a big problem, is because sometimes they don't really enforce this. So you might get calls from certain companies, like, for example, other banks that you don't deal with, who are trying to sell you a product, or insurance companies. So what is the requirement of organizations? First of all, you have to be registered as an organization, a registered information officers with the regulator, written notifications for POPIA on why information is being collected, how it will be used and stored. So whenever you go to a company, and even if you look at the university websites, for instance, you will always see something on POPIA and what information they need, what information is being collected, and for what the purpose is of this information. Mechanisms to request if a company has personal information, what the information is, and request to stop processing or remove personal information. So you have a right to actually say, I do not want my gender to be revealed, for instance, or a race is another one, which is the typical example. Then we have methods to report concerns or breaches, integration of privacy into risk management, which is to conduct risk assessments related to privacy. POPIA compliance frameworks have to be in place within organizations, and you have to have an information security policy. So if we look at the compliance framework, we have governance framework, which is your information governance. We have risk assessments. We have your internal policies for privacy and protection of personal information, accessing information, and information security. You also need or have to comply to personal information and the impact assessments, records management, technical and process controls, breach management, and you have to have a review process. So going back to the case, it was the first case that was prosecuted or went to court was one involving the state versus Erasmus. I'm not sure of the year of this to be exact, but it was the leakage of information or private information to other members of the company. So while HR may have information on a certain individual, they're not allowed to disclose it to anyone else unless it is a line manager with you being notified before this happens. So the next one we have is Promotion of Access to Information, which is Act 2 of 2002 with amendments. The key point is it allows for individuals or groups to request information that is not publicly available. So if you are requesting information about either an individual or a group, you can actually put in a PAIA application to request the information, providing that it does not infringe on POPIA. So this is the tricky part that we have to consider. It also requires an information officer to be appointed. Organizations have the right to refuse to release information on certain grounds. So if you are asking information about a certain individual and you put in a PAIA application, but you don't have a good motivation for it, then of course it will be denied. Usually you may be requested for information that would be for the public good to be known. So it's not just, I had an argument with someone, so I want information on them. So PAIA gives an introduction, requesting public information, requesting access from private organizations. Part 4 states appeals against decisions, rights to access, availability of publication of records, methods of access, grounds for refusal to access, and third-party notification. Now, the most important act was first drafted in 2015, revised in 2017, finalized in 2018, but only enacted in 2021. Now, this is the Cybercrimes Act. So just a few key points. It defines cybercrimes and malicious communications. It authorizes powers to investigate, search, and access or seize. It deals with assistance and collaboration, including with foreign organizations. It deals with evidence or the chain of evidence, obligations of service providers. So what are your service providers actually obligated to do? So for instance, if you've been receiving calls or unsolicited calls, you can actually ask for an interdict, which does take a lot of time. But at the end of it, service providers would need to give you the information that you required. Obviously, there is a long process to this, but if you get that court interdict, say that this person has been harassing you for whatever reason, and you can get that information. This is a long process. We also look at the implementation of structure for cybersecurity, your critical infrastructure protection as well. So the next one is your cybersecurity policy framework, which came out in 2012, which establishes government's strategic approach to cybersecurity. It calls for protection of critical information infrastructure and coordination among state agencies. It deals with the implementation, which has been slow with limited institutional capacity. Capacity is also a huge issue. So let's look at some of the challenges to critical infrastructure legislation. So firstly, we have the law and policy. Then we have the focus area, and then the gap in infrastructure protection. So if we look at the Cybercrimes Act, the focus area is criminalization of offenses, but there is a gap here, and it's limited focus on resilience rather than everything else. So it's very limited in terms of what it is able to do. The second one is POPIA, which is your data focus area is data protection, indirect infrastructure coverage. That is the gap in the infrastructure protection. Your national cybersecurity policy, the focus area is strategic coordination. And this is an important one because in many cases you can enact something, but it gets caught up in implementation and enforcement. So I think those are two important areas that you need to look at. ECTA, which is your Electronic Communications and Transactions Act. Electronic transactions are the focus area, and it often has outdated provisions. It does get updated, I think, every 5 years or so, but they just do it as amendments to the original act. Okay. I think these are the incomplete slides. I'm just going to stop sharing before we get to the next lot.
All right, thank you, Dr. Ramluckan. Are we moving on to the next part, or do you want to move over to questions?
I'm going to go through the next part. It's just, I think it is giving me a bit of an issue.
Okay.
Are there any questions? I will take questions if that's okay.
I will have a look at the Q&A box. Please, everybody, use the Q&A box purely for questions for Dr. Ramluckan.
I've done the basic laws. I just went on to the challenges, and it seems to have kicked up. So.
All right, I have one question here, Dr. Ramluckan, if you're ready.
Yeah, sure.
What actions could you unintentionally violate laws like the Cybercrimes Act when it comes to incident responses?
So first of all, we have to move to crisis communications and crisis management. So we do have the Disaster Management Act. We do have the ECT Act, but it depends on the severity. So organizations are given a chance to rectify if there is a breach. So you do have a chance to actually do the minimum that you can do. And if this does not work, you can actually go to the prosecuting authority where they can find evidence and take it further. But in that all said and done, enforcement becomes an issue because basically it takes quite a few sometimes up to a few years to be able to enforce what has been said, and sometimes it keeps going from one court to the next. Okay, are there any more questions?
All right, I see that your slides are ready. Then we can move on to the second part.
Okay, so besides this, we have your PFMA.
I think we're having some audio issues. Can you hear us, Dr. Ramluckan?
Yes, I can. So
All
we're
right.
going to go to okay, so it's Act 1 of 1999. The key points: it provides a minimum standard for accounting and financial management of public institutions. At the moment, educational institutions are not recognized under PFMA as a public institution under this act. However, it should follow shortly. It deals with financial misconduct, fruitless and wasteful expenditure. And this, of course, can apply to IT in terms of projects, budgets, and so forth. This is a good one. It's your Film and Publications Board Amendment Act. Some of the clauses on responsibilities related to social media posts. It deals with hate speech and incitement to violence. It deals with revenge porn. It deals with group page admins, owners, accountable and responsibilities. It sets offenses and consequences. Now, this is one that is important, but a lot of people including attorneys, don't actually use this act because they don't know how far it's been amended. Your Consumer Protection Act, or your CPA, it protects consumer rights. It can apply to IT services and contracts, allows for opt-out of direct marketing. Direct Marketing Action Association South Africa opt-out list. So you can actually register on a website that you don't want direct marketing. So technically they should not be calling you, but of course you do get the incidents where they get your number from somewhere and they do actually call. We also have an artificial intelligence legislative policy framework for 2026. It's only to be finalized in 2027. And the policy has entered the cabinet for approval process and is expected to be gazetted for public consultation. So the finalization is targeted for 2026, but I would say more 2027. Government has opted for a sector-specific multi-regulator model rather than a single AI regulator, and it has 5 guiding pillars. So we have skills capacity, responsible governance, ethical and inclusive AI, cultural preservation, and human-centered deployment. So there are risks and recommendations for the AI legislation. So the area is governance model. The current approach is we use multi-regulators. The risk means lots of fragmentation, and the recommendation means we need a central coordination body. So timeline, policy by 2027, and the risk is that we do have delays. As in the case of POPIA, it took about 10 to 14 years to actually get it enacted from the first draft. We have to find a way to accelerate consultation, so all stakeholders need to be consulted in time. The next area is ethics. So we have guiding principles, but of course the risk is weak enforcement, and the recommendation are mandated standards. Skills, limited expertise. Now in South Africa, we always need a suitable qualification in that field to be able to actually practice in that field. So if you were an attorney that dealt with labor law and you want to go into cyber law, it is a whole process because obviously you've not been educated in that field. Compliance gaps are the risk. National training programs are your recommendations. If we look at global alignment, we have a very slow adoption. We seem to be falling behind the EU and the US, and the recommendation is that we need to have regional and global cooperation, which is sometimes very difficult to do. Now, in Africa, we have our SADC, or South African Development Community. Just a brief history, the Southern African Development Community is a regional intergovernmental organization made up of 16 member states across Southern Africa. These are inclusive in the map. Its mission is to promote sustainable and equitable economic growth, deeper regional integration, and political cooperation amongst its members. So what it does is it provides a framework for regional cooperation, usually in trade, infrastructure, and education. It plays a role in conflict resolution and peacekeeping within the region. It also helps member states to collectively address climate change, energy transition, and food security challenges. So if we look at cyber in particular, SADC has the digital transformation strategy, which started in 2022 and it goes up to 2030. It includes cybersecurity as a cross-cutting issue, aligning with the African Union's digital transformation strategy and the UN goals for safe digital connectivity. It emphasizes building secure digital infrastructure and harmonizing member states and their approaches. It is regionally indicative strategic development plan. It addresses and identifies digital security as essential for economic integration and resilience. We also have what is known as the Regional Cybersecurity and Cybercrime Strategy in your East Africa, in your West African cybersecurity framework. The purpose is to guide member states in developing national security policies and strategies. The key objectives: establish national cybersecurity authorities, prioritize protection of critical infrastructure and essential services. It enhances cybersecurity skills and capacity building, and it's there to actually promote regional and international cooperation, so sharing information and having joint investigations. The other one is also West African. It's your Organized Crime West African Response on Cybersecurity and Cybercrime. This is funded by the European Union, and it has been implemented with expertise from France in partnership with ECOWAS commissions. Focus areas such as computer security, incident response teams, or your CSATs, training for law enforcement, judiciaries, and cybersecurity professionals, and the development of ECOWAS Cyber Portal as a knowledge-sharing platform. The important or most important one in Africa is your Malabo Convention. It's formally known as the African Union Convention on Cybersecurity and Personal Data Protection. It's a key treaty that was adopted by the AU in Malabo, Equatorial Guinea. What must be noted is South Africa is not a member or a full member of the Malabo Convention due to not reaching an agreement on certain aspects of the convention. One of the main aspects was your sovereignty and your digital security. So they didn't want information going out. So there are just some key themes on the convention. Your personal data protection. So every individual, every state has the right to personal data. In some cases, we have legislation that actually is able to intercept this information if a certain crime or wrongdoing is actually being established. Cybercrime and cybersecurity, it requires national cybersecurity policies and strategies. Now, this provides penalties, for example, hacking, data interference, identity theft, cyber fraud, child pornography, and so on. Your electronic transactions, it establishes rules for e-commerce, including electronic contracts, signatures, advertising, and payment security to build trust in digital trade. Excuse me. The treaty emphasizes balancing security with human rights. So it brings in your human rights elements, which are based, or standards that are based on the African Charter on Human and People's Rights. So we're going to look at some of the challenges. First of all, there is a lot of fragmented legislation. Second of all, the enforcement gaps. So in legal wise, it's very, very difficult to actually enforce what the court has laid down. So while it is the court's decision to actually penalize someone, it becomes an issue of, would the company or companies be able to enforce this? Rapid technological change. So legislation can't keep up with technology because of the process that legislation has to go through. Next, of course, is capacity and skills shortages. We all know that cybersecurity is fairly new. And in South Africa, we don't actually have complete degrees. I think maybe one or two institutions do have it, but it's more of a diploma or a postgraduate degree, diploma as well. Next is critical infrastructure vulnerabilities. They are always vulnerabilities in your infrastructure. The problem comes in is when your hospital's databases are breached and information goes out, or certain things are shut down, like I would say maybe load shedding. Load shedding is done by the government or the municipalities, but then again, if a certain individual decided, no, I'm going to shut down something and extort money for it, then it becomes a huge vulnerability in their system. Next is geopolitical and international pressures, which depends on which side you basically want to fall. So for South Africa, it's the East versus the West. So I think every country has that issue as well. South Africa's legislative framework is ambitious, but struggles with implementation, adaptability, and coordination. So South Africa is also caught between, I'd say, modernizing rapidly and ensuring governance keeps its pace. Some examples are fragmented laws, which is a challenge. The impact on legislation is there's a lot of confusion because you have to go to fragmented bits of legislation to get to one point. So there's not one set of or one piece of legislation that you can actually use. Weak enforcement. So there is a lot of weak enforcement because while you may win a case, say because of breach of POPIA, for instance, you can get a decision made, but sometimes it takes a while before it's enforced. So an example is POPIA versus the Cybercrimes Act, which of course overlap. Enforcement gaps is another challenge. Low conviction rates is the impact on legislation. Difficulty prosecuting ransomware is the context. So if you look at things like attribution, it becomes very, very difficult because ransomware is who is responsible or liable for this ransomware attack. You have to be able to attribute it. The next one is tech evolution. So we have outdated frameworks. And of course, we have our normal AI and IoT risks. Skills shortage. The impact on legislation is poor execution because we don't have enough skilled capacity to actually be able to execute it properly. The example context, we have overwhelmed SOC teams. The next challenge is infrastructure attacks. So impact on legislation is your national security risk. Example context, so we had a breach of ransomware in 2024, which impacted your government and impacted your healthcare sector. Geopolitical pressures, weak global cooperation. South Africa values its sovereignty, which means that it becomes very difficult to collaborate on certain issues. And the context of it is cross-border cybercrime. So how do we deal with that? So in some countries, you have the ability to extradite, and which is you have agreements between nations. But in South Africa, it's a lot longer to process this, and sometimes it doesn't even happen. If you look at the possible reforms, they are legal clarity, which have overlapping laws, proposed actions, which harmonize frameworks, and the expected impact is simplified compliance. The next one is your reform area, which is enforcement. Here we have a skills shortage. So what's needed is specialized training in courts and stronger prosecutions. Critical infrastructure, we have vulnerable sectors. Proposed action would be your sector-specific standards, which would become more resilient. Collaboration, we have fragmented efforts, public-private partnerships, and faster threat response. Your international cooperation, the current gap is weak treaties, proposed action, regional and global agreements, example extradition, and then we have cross-border enforcement, which is your expected impact. Then we have tech adaptability. The current gap is our outdated laws, and obviously to update the laws and amend them, we have to actually go through an entire process. The proposed action is a standing review body, so we have one body that could possibly review the laws. Future-proof legislation is the expected impact. Okay. Thank you for your time. I'm sorry about the delay.
All right, thank you so much for this very insightful lecture. I've collected a couple of comments from the students. If you can maybe answer 2 or 3 of them, because we're going over time, but we want to give them the opportunity. So the first question we have is there a plan to regulate PAIA and or the cybersecurity framework?
So the cybersecurity framework has been in process for a really long time. So we do push for it to actually be implemented and to be regulated, but of course we still have the issue of we don't want it to clash with other regulations. And what was the second one? Sorry.
The cybersecurity framework.
Yeah. So the cybersecurity framework is what initially happened is we had the cybersecurity and cybercrimes bill in one, and now they just split it and they just put it under the Cybercrimes Act, with the potential of actually completing the cybersecurity aspect of it, which there's been little to no news on. But we do know that they are developing the framework into an actual bill, and from the bill, it will be passed on to an act.
All right. Then another question that we have that I think is very interesting is what are some of the real life consequences that maybe some of the participants can feel resulting from the challenges in the infrastructure that's currently existing in South Africa?
Okay. So, look, I mean, realistically, I think everything gets held up in our court processes. So we have an ombudsman, for example, but if you have, or if you feel that you have been, say your privacy has been violated by a company, you can actually complain to, we have, say it's an internet service provider. We have a body in place. You can report it to the body. First, you report it to the actual service provider. If they do nothing, then it goes on to the body, I think it's ICASA, and then it goes up. If they find that there is enough information, then you can actually take it or be able to prosecute. But this again it might go to the High Court and then the Constitutional Court if it's not been resolved. So it's a long process. So that's one of the challenges. I think everything gets caught up in process. So sometimes they tell you give them 2 weeks. Sometimes they'll tell you give them 3 weeks.
All right.
So I think all of that becomes an issue.
Okay, good answer. Thank you so much. Then maybe a bit of a different question for the students who are interested in maybe a career in cyber law or studying this. What advice would you give them?
I would say also, besides just having the theoretical knowledge, it's also good to have a bit of technical knowledge. So you know how the technology works in order for you to know when to implement what areas of law. So I think you need to have some technical background. It covers overall what you need to know.
All right, thank you so much. I think we're going to wrap it up there so we don't go over time too much. I want to thank you so much, Dr. Ramluckan, for hosting this super insightful session and kicking off our cyber school this year.
Thank you. It was a pleasure, and thanks for inviting me.
All right. Thank you all, and we will see you all tomorrow.